Good morning, ladies and gentlemen. Welcome to this morning's webinar on settlement agreements. I'm now going to hand over to Danielle Kingdon, Partner in Employment.
Hello everyone, welcome to today's session where we're going to look at the circumstances in which you might want to use a settlement agreement and the most important things to bear in mind when you are negotiating a deal with an employee. I'm Danielle Kingdon, a partner in Osborne Clark's employment team, and I'm very pleased to be joined today by Emma Ladley, a senior associate also in our employment team. When the employment relationship's not working, following a lengthy process can waste management time and prevent the business from moving forward. This morning, I'm going to run through how you can use a settlement agreement to quickly part ways with an employee at the same time as waiving any legal claims arising out of their employment or its termination. I'm going to particularly look at the key things you need to bear in mind when you're negotiating the deal and also when you are setting out the terms of the settlement agreement. Basically, how you get the best out of the process. We're going to look at, firstly, when you should consider a settlement agreement, the without prejudice and pre-termination negotiation rules, what can and should form part of the deal, the key clauses and protections, how to optimize tax efficiency, the extra considerations when parting company with shareholders and directors, and lastly, the legal formalities for a valid agreement. Today's session will take around 35 minutes, then we have 5 minutes to discuss questions which some of you have kindly submitted already, and which any of you can post during the webinar by typing questions in the instant messaging window that should be displaying at the side of your screen. So what is a settlement agreement? Well, it's a legally binding agreement in which the employee agrees not to pursue particular claims in return for a financial settlement or other benefits. Some of us who have been working in the employment arena for a while will recall these agreements used to be called compromise agreements. But other than a name change, the basis of these agreements remains unchanged. A settlement agreement enables an employer to terminate employment immediately by effectively buying off the employee's rights to a fair process. We will all be aware of how long a redundancy, poor performance or disciplinary process can run for, so circumventing these processes can sometimes be a very attractive option. In my experience, it's not just the employer who stands to benefit from the use of a settlement agreement. It can often be the most constructive option for both parties, particularly where there's no hope of the situation being salvaged. The employee is spared a drawn-out process, which can be demoralising and corrosive to self-confidence, and the employer avoids the loss of management time and is able to quickly get in place someone more suitable for the job. But remember, a settlement agreement is not always required for a speedy employee exit. Where the employee has only contractual claims, a simple waiver agreement releasing the claims is sufficient, and the employee will not need independent legal advice for the waiver of contractual claims to be legally binding. Of course, if you follow a fair process to address poor performance or a redundancy situation, you may not need a settlement agreement, as no claims should, in theory, arise. However, as most of us will have experienced, following a fair process does not prevent disgruntled employees bringing complaints. So in these circumstances, a settlement agreement may again be the best option. The Employment Rights Act allows for discussions called pre-termination negotiations to take place between an employer and employee with a view to ending the relationship under a settlement agreement. This is without these conversations being admissible as evidence in most unfair dismissal claims. In fact, the recent Employment Appeal Tribunal decision in Fairthorne Farrell Timms LLP and Bailey has confirmed that the inadmissibility of pre-termination negotiations applies not only to the content of any offers made or discussions held, but also to the mere fact that there have been such offers or discussions. This means the employee cannot rely on the existence of such negotiations in support of an unfair dismissal claim. This case also established that the pre-termination rules render inadmissible not simply the relevant discussions between the employer and the employee, but also discussions within the employer company, such as those between different managers or between a manager and HR. Before the introduction of pre-termination negotiations, there was always the risk that an employee could claim that an offer from the employer of favourable exit terms was a fundamental breach of trust and confidence, enabling the employee to resign and claim constructive dismissal. This meant that there was no going back from this type of conversation, and so no opportunity to effectively test the water. Whilst pre-termination negotiations are undoubtedly good news for employers, they don't enjoy unlimited protection. Most importantly, negotiations are not protected if the employee has been dismissed for an automatically unfair reason, such as taking maternity leave or demanding to be paid the national minimum wage. Where this is the case, the content of the discussions can be used as evidence in an unfair dismissal claim. More generally, if something is said or done that in the tribunal's opinion is improper, such as bullying during the negotiation process, the content of the discussions is protected only to the extent that the tribunal considers just. However, unlike without prejudice privilege, pre-termination negotiations privilege cannot be waived by the parties both agreeing to lift the veil on the pre-termination discussions, as recently confirmed in the Fairthorne case I referred to a couple of minutes ago. The key limitation of pre-termination negotiations is that the confidentiality of negotiations applies to unfair dismissal claims only. So the contents of negotiations can be relied upon for other types of claims, such as discrimination and breach of contract. For this reason, the without prejudice rules remain an important part of negotiations for you. In order to attract the protection of the without prejudice regime, you must be able to establish that the employee consented to your discussions being held on a without prejudice basis and understood what this means. In an ideal world, you would write to the employee in advance, inviting them to a without prejudice discussion and explaining what this means. This way, the employee cannot later argue that they were ambushed and didn't understand the basis on which they were discussing terms with you. The reality is that most employers tend to seek the employee's consent to without prejudice conversation at the beginning of a meeting. If this is the approach you take, you should be careful to explain what without prejudice means and to obtain the employee's consent to continuing on this basis. In 99 cases out of 100, the employee will agree to proceeding as they will want to know what the meeting is about. Make sure you take a note of their consent as part of your minutes of the meeting. To benefit from without prejudice protection, there must be a pre-existing dispute between the employer and employee, and the negotiations must be a genuine attempt to settle that dispute. This could be, for example, a dispute over an ongoing poor performance process, selection for redundancy, or the outcome of a grievance process. If an employee alleges that without prejudice negotiations have been tainted by perjury, blackmail, or other unambiguous impropriety, such as discrimination, the without prejudice protection does not apply. A basic example of this would be if an employer tells an employee she is being dismissed because colleagues are uncomfortable with her religious beliefs, or a team member is told they don't fit the dynamic of a team because they are older than their colleagues. These are very obvious examples, but you can appreciate that the scope for allegations of discrimination is quite wide. If you are concerned about whether without prejudice protection will apply, think carefully about what you communicate and take legal advice as soon as possible. Moving on to how you go about negotiating a deal with the employee, it is fair to say that in most cases, an employer's solicitor will produce a draft settlement agreement to get the process moving. The most significant part of the deal offered to the employee is likely to be the termination payment. So how much should you offer in the settlement terms you propose? It's human nature to try and negotiate a better deal than the one you are initially offered. This, coupled with the employee's legal advisor wanting to add value through their legal advice, makes it very likely that an attempt to negotiate up any termination payment will be made. With this in mind, you can either adopt a take-it-or-leave-it approach or start with a lower offer, knowing that you are prepared to offer more if necessary. There are pros and cons to each approach. The take-it-or-leave-it approach can force a quick settlement and save money, but is only advisable if you are really prepared to stick to your guns. Are you prepared to keep the employee on and follow an on-the-record process if you can't reach a settlement? Offering a little more in negotiations is often worth it, as it saves on all the other costs associated with a protracted negotiation. If you've started with a low offer, you can end up settling for the amount you were comfortable with in the first place. Remember, the termination payment should be based on compensating the employee for their loss of employment. If they already have another job, or you believe you could fairly dismiss them in any event, you can be robust in your negotiations. Where you're making a payment to circumvent having to follow a fair process, but feel if the process was followed, the employee would be fairly dismissed in any event, think about the period of time you're compensating the employee for. In other words, how long would that process have taken? Once you have determined the termination payment you're prepared to offer, or at least your starting offer, the next thing to consider is whether you will pay it in one go or stage your payments. Clearly, most employees would prefer a lump sum payment, but you may want to make the payments in stages, for example, to help enforce covenants the departing employee has given, or to wait until the time period for bringing a particular claim has expired. Being paid in stages can sometimes also be advantageous for the employee, as it can affect the amount of tax they pay. All offers should be made to the employee on a without prejudice and subject to contract basis. We have talked about the without prejudice aspect of negotiations, but what is the significance of negotiating subject to contract? Conducting negotiations subject to contract means that until the settlement agreement is signed, its terms are not binding on either party. It is not unknown for new information to come to light during negotiations, with the result that you might no longer wish to go ahead with a favourable financial settlement. For example, if you were to discover that the employee in question has committed gross misconduct and can be sacked immediately without notice, offering more favourable departure terms is no longer an attractive way of managing their swift exit. More often, it is discovered that an employee claiming compensation for loss of employment has already accepted another job, therefore significantly mitigating any losses they are being compensated for. To find out whether this is the case, we recommend that the employee is required to warrant in the settlement agreement that they have not already secured alternative employment. This can sometimes flush out useful information with which to negotiate down any payment calculated on the basis of future loss. A warranty that the employee has not committed any breach of their employment contract that would have entitled you to summarily dismiss them should also be included. You need to make clear each of the complaints being settled and set them out in the settlement agreement. The agreement should include a warranty that the employee has disclosed all known claims at the date of signing the agreement. It is arguable whether claims that the employee is not yet aware of can be waived, but it is common practice to attempt to settle future claims with a catch-all clause. If a personal injury claim has already been brought in the civil courts, a draft consent order should ideally be agreed and annexed to the agreement in order to waive this claim. Not all employment claims can be settled by a settlement agreement. Some can only be settled following ACAS conciliation. For example, claims for a failure to inform and consult with appropriate representatives on collective redundancies, and claims for failure to inform and consult or to provide employee liability information under TUPE 2006. Some claims have no apparent means of waiver at all. There is an absolute restriction on contracting out of paying statutory maternity, paternity and adoption pay. However, the common practice to get around this is to deter the employee from bringing these claims by stating a breach of the terms of the agreement, or bringing a claim in respect of his or her employment or its termination will make all or part of the severance payment repairable. In addition to the terms documenting the claims waived by the employee and the financial settlement to be provided, there are a number of other clauses you would typically expect to include in the settlement agreement. Firstly, an agreed form of reference for the employee is standard. This can just give basic information only or be more qualitative. It is in both parties' interest to specify exactly who is permitted to provide a reference and its exact terms. There is an obvious tension for employers asked to give a reference for an employee who is leaving due to poor performance or a disciplinary matter. In these circumstances, a reference confirming just the employee's role and dates of employment is the best option. Even this approach is not risk-free, as the old employer owes a duty of care to provide an accurate reference to the potential new employer. Failing to reveal details of a serious performance or disciplinary matter can create liability. However, unless the disciplinary or performance issues have been properly addressed through a formal process which has given the employee the opportunity to respond to the accusations, an outgoing employer is best providing a very basic reference only. From this summer, financial services firms are expected to be subject to specific rules for providing regulatory references, which will dictate the format and type of information that must be provided. An obligation on the employee to return all company property, including copies of confidential information, and to confirm that any soft copies held by them have been deleted, is very much standard in a settlement agreement. It is good practice to list all physical property to be returned, such as laptops, security cards, and company vehicles. An obligation to keep both the terms of the settlement agreement and the company's confidential information confidential should be included. Looking firstly at an obligation to keep the terms of the settlement agreement confidential, if the obligation to keep the agreement confidential is made mutual, consideration will not need to be provided for this promise from the employee. However, if the obligation is not mutual and only the employee is agreeing to this term, it's a good idea to allocate specific consideration to the confidentiality obligation. Turning now to protecting the company's confidential information post-termination. In the absence of an express provision, protection after termination will only extend to information which is so confidential as to amount to a trade secret. Therefore, employers often opt to repeat any express confidentiality provisions that are contained in the employment contract, making clear that they survive termination. However, if there are no such provisions which can be lifted from the employment contract, you may wish to draft fresh confidentiality provisions which go beyond the scope of the implied duty. If so, it will be necessary to portion specific consideration to any fresh confidentiality obligations, as they will be liable to tax. Any confidentiality provision must make it clear that it is without prejudice to the employee's right to blow the whistle, provided they comply with the legislation on protected disclosures. I'm going to look now at bad-mouthing clauses. An agreement not to make derogatory comments is a key clause, often referred to as bad-mouthing clause. An employee is usually permitted to discuss their settlement terms with their partner and obviously their legal advisor, but not more widely. The clause is often made mutual, particularly where the employment relationship has ended acrimoniously. Employees will often request that the content of an internal and external announcement is agreed with them, so the narrative about their departure is controlled. This can be annexed to a settlement agreement so all parties are clear what message will be communicated about the termination of the employee's employment. If the employee is resigning any directorships, a resignation letter should be attached as a schedule to the settlement agreement. Settlement agreements often include a power of attorney, giving the employer the power to effect a resignation on the employee's behalf if they fail to resign from any offices held. If a power of attorney is included, the settlement agreement must be executed by deed. Emma's going to talk more about the specific considerations for shareholders and directors later on. A contribution to the employee's legal costs is standard, partly because an employee is required to obtain legal advice for the agreement to be valid, and partly because of the tax saving available if the employer pays towards the employee's legal fees. In our experience, the amount contributed can vary widely and depends on factors such as the circumstances of the employee's departure, the degree of fault on the employee's behalf, the complexity of the issues being settled, and the extent to which the employee is already getting a good deal. Providing too great a contribution to legal fees can be an incentive for the employee to keep on going with a negotiation via their lawyer, so this should be borne in mind. A going rate for a contribution to legal fees is probably somewhere in the range of £250 to £750 plus VAT, but for board-level dismissals, where the transfer of shares is involved, contributions can be much higher. Remember, for the employee, a higher contribution to legal fees will be advantageous from a tax perspective and is often offset against any termination payment where the termination payment exceeds the £30,000 tax-free limit. Including a tax indemnity from the employee protects you from any further tax or employee national insurance contributions pursued by HMRC on the termination payment or any other payments. Whilst an indemnity provides protection for an employer, it is better to be clear on the tax position of the payments being made under the settlement agreement in the first place. Where the position is unclear, for example, where there is custom practice of making payments in lieu of notice but no express provision in the contract, we recommend that you tax the payment and let the employee claim the tax back from HMRC. Another provision worth including is a reaffirmation clause. It's sometimes the case that there is a gap between the employee signing a settlement agreement and the termination of their employment. Where this happens, there is a risk of additional statutory claims arising in the period between signing the agreement and the termination of employment, and these claims would not be covered by the employee's original waiver of claims. This can expose you to a claim which has not been settled by the agreement, and this obviously defeats the object of you making a payment to settle all the claims. There are a couple of ways to get around this problem and ensure that all claims are effectively compromised. The most common approaches are to require the employee to re-execute the settlement agreement on or after the termination date, or require the employee to re-execute or reaffirm certain provisions of the settlement agreement in a separate reaffirmation letter on or after the termination date, or lastly, you can hold the agreement and termination payment in escrow until the termination date has arrived or passed. With the first two methods involving re-execution or reaffirmation by the employer will need to receive independent legal advice again, as there is a repetition of the waivers. Therefore, a second advisor's certificate will be necessary to make the settlement agreement valid. Ultimately, it is a judgment call as to whether a re-execution or reaffirmation is necessary. I will now hand you over to my colleague Emma Ladley, who's going to cover the rest of our topics this morning. So over to you, Emma.
Thanks, Danielle. So good morning, everyone. I'm Emma Ladley, a Senior Associate in the Employment team at OC. A big part of my work is in assisting our clients with negotiating and effecting settlement agreements. And quite often, a major part of the negotiations themselves is in the tax treatment of the payments being made to the employee. It's important to be aware that not all payments made under a settlement agreement can be tax-free. Back pay, commission and bonus payments, as well as holiday pay, are all fully taxable. Compensation payments for loss of employment, which are also referred to as termination payments, are taxable to the extent that they exceed the £30,000 tax-free exemption. This £30,000 exemption also includes redundancy payments, and so there isn't a separate £30,000 exemption for each. Payments in lieu of notice, also referred to as pylons, are taxable if there's a contractual right for the employer to terminate with a pylon in the employee's terms of employment. And this includes situations where there's an implied contractual right, which is developed through a custom and practice of making a pylon on termination, or where it's the employer's automatic response on termination of employment. Where there's genuinely no contractual right to terminate employment with a pylon, then doing so is a breach of contract, and so the resulting payment is treated as damages and falls within the £30,000 exemption. Contributions to an employee's legal fees can be made free of income tax if they're paid directly from the employer to the employee's solicitor, and as long as the fees relate purely to the advice on termination of the employment. Clauses imposing new restrictive covenants or confidentiality obligations should be allocated a specific payment which will be fully taxable. However, the reiteration of existing terms doesn't require the allocation of a payment, as Danielle has already mentioned. The option of paying part of a termination payment into an employee's pension scheme can be a useful tool in negotiations. Employer contributions into registered pension schemes can be made tax-free and without using any of the £30,000 exemption. However, if contributions exceed the annual allowance or the lifetime allowance, then a tax charge will arise to claw back excess tax relief. A tax indemnity from the employee should always be included in the settlement agreement, and this places the responsibility for paying any unpaid tax with the employee. If the departing employee is a shareholder, then the shareholder agreement or a share option plan, as well as the Articles of Association, will also need to be reviewed to understand any terms relating to termination, and this includes any good and any bad leaver provisions. You will need to address how the shares will be valued and how the buyback will be funded. When referring to shares and share options in a settlement agreement, care must be taken to avoid making contractual promises that the company doesn't have the autonomy to deliver on. For example, if the share plan is operated by a group company, or which fetter the board's discretion under the share plan rules. For example, do share options vest in full or in part, or do they lapse on termination? Does the company have a discretion in this regard? Bear in mind that if a settlement agreement is entered into after termination of employment, options and awards may have already lapsed under the plan rules, and where this is the case, they cannot then be revived. Where an employee is a director of a listed company, then any decision in relation to the employee's options and awards will need to comply with the company's published directors' remuneration policy. Otherwise, shareholder approval will be required. The timing of any external announcements will also need to be planned for. For a settlement agreement to be legally binding, a number of important conditions must be fulfilled, and these are in essence that the agreement must be in writing, it must relate to the particular complaint or complaints of the employee, the employee must have received independent legal advice from a relevant advisor as to the terms and effects of the agreement, and in particular, its effects on his or her ability to pursue rights before an employment tribunal. There must be in force when the advisor gives that legal advice, a contract of insurance or professional indemnity insurance covering the risk of a claim by the employee in respect of loss arising as a result of the advice. The agreement must identify the advisor, and the agreement must state that the conditions regulating settlement agreements under the relevant legislation are satisfied. The people who are eligible as relevant advisors in this context are qualified solicitors and legal executives, and in some cases, employees of trade unions and advice centres, but in the vast majority of cases, you'll find that you'll be negotiating with another employment lawyer. Bearing in mind that an employee is required to seek independent legal advice on a settlement agreement, you should give serious consideration as to whether or not one is really necessary in your circumstances, particularly where you feel confident that you've dealt with matters by the book, or where the likelihood of the employee bringing a claim is low. Remember that if you just want to settle contractual claims, then you don't need a formal settlement agreement in the sense that we're discussing them today, and a contractual waiver of claims will be sufficient. So that's all from Danielle and I on when and how to use a settlement agreement, and I'm now going to hand back over to Danielle, who's going to have a look at the first of your questions.
Thanks, Emma. So it's time to move on to the question and answer session, and we're very grateful to all those who've submitted questions. I think in the time available, we will prioritise by looking at the 2 questions with the most relevance to all our listeners. If we don't get to your question now, we'll respond after the session. And please do feel free to contact Emma or me directly. You can see our contact details on the last slide. We've had quite a few questions, and the first one is this. Can you impose stronger restricted covenants in a settlement agreement than are in the employment contract if you compensate the employee for the new restrictions? And are the limits on enforceability of restrictive covenants under a settlement agreement wider than those that apply to an employment contract? I think it's true to say that the terms of the settlement agreement can be challenged, and there is a definite tension created by the fact that while restrictive covenants contained in the agreement are subject to the normal restraint of trade principles, as they would be in an employment contract, there is a public policy argument that the terms which parties have agreed should, of course, be respected. There was a case not long ago involving Capgemini in which the High Court took into account Court of Appeal guidance on this very point and held it's for the employee who's seeking to avoid the agreement to prove that particular grounds justify them doing so, rather than it being for the employer to prove that the agreement was reasonable. So I think this is quite helpful guidance for employers particularly. So in practical terms, it might be easier to persuade a judge to enforce a covenant that has been specifically negotiated and entered into on termination where the employee has the benefit of legal advice and has received specific payment for entering into the restraint. Depending on the circumstances, the employee may no longer be considered to be in an unequal bargaining position, but able to decide freely and with the benefit of advice whether they wish to enter into the restraint. I'm now going to hand over to Emma, who's going to answer our next question.
Thanks, Danielle. So our next question is whether you could use a settlement agreement to compromise any employment claims that a consultant would have if he could establish that he is an employee. So in other words, can you have a valid settlement agreement with a consultant to waive employment claims? Now, the fact that the individual may or may not be an employee won't affect the validity of a settlement agreement at all. The agreement will waive any contractual claims as well as any statutory claims that they might have, such as unfair dismissal or discrimination claims. And in fact, consultants may have some statutory rights anyway, for example, discrimination or in some cases working time regulation claims. And so using settlement agreements for consultants isn't that unusual. And in our experience, where there's a concern on termination about the status, then this is the belt and braces approach, although there may be some differences in the terminology used. You will though need to be careful about the tax position here, as there needs to be an employment relationship being terminated if you want to take advantage of the £30,000 tax exemption. So hopefully that answers the second question, but as Danielle has said, please do just get in touch with either of us if you have any questions.
Thanks, Emma. That's the last question that we have time to cover, but if there are others that occur to you, as I said, please do come back and contact us directly. But I think we're now at the end of this webinar, and it just remains for both of us to say thank you very much for listening, and I hope that you all have a good day. Thank you.